What did this crazy woman say? Charity Colleen Crouse hereby presents a motion for leave to amend a complaint in Charity Colleen Crouse versus Judge Renee Harris Toliver and Judge Ed Kinkeade, case number 3:20-CV-00113-N, as well as related case, Charity Colleen Crouse versus Texas State Senate, case number 3:20-CV-00114-X, per local civil rules 72.1 briefing practice concerning objections to magistrate judge orders in non-dispositive manners. You know what this sounds like? You had to get some Jews to open up some lines of finance, and then what? You were going to get the 0.1% cute, sweet little blonde girl to pay the tax? And that's what happened yesterday. That's what happened yesterday. You got a whole bunch of accounts connected to Jewish women from the United States, by the way. You guys have a thing with lesbians. I don't know what that's about. And then what did I say? I said you were going to only work accounts connected to African Americans in the Marine Corps. And then what happened? For a little while, I got my girl. I got my Class A, but only long enough to be in excruciating, horrible pain while I worked the tax. Then you wanted me to transfer it to San Francisco. But that's not what happened last night, is it? What are you Nazis doing trying to interfere in matters connected to another country and trying to convince me that it's nothing more than some horny local boys? Plaintiff and representor Charity Colleen Crouse contends that thus far her efforts to represent herself pro se have been accorded not only an unfair disadvantage in terms of access to protections that an attorney would be afforded in connection with their client, but subjected to discriminatory and derogatory treatment by other legal professionals who do enjoy the advantages and privileges of designation as an attorney. The application for admission pro hoc vis requires reading of a case decision that describes the types of behaviors that an attorney engaged in a legal proceeding can expect from another attorney in that legal proceeding. Charity Colleen Crouse has been repeatedly denied this form of decorum by thus far every member of the legal community she has encountered, regardless of the jurisdiction under consideration, for going on 4 years. During this time, Charity Colleen Crouse has likewise been refused any representation, counsel, or assistance by anyone considered officially to be an attorney per membership in the State Bar of Texas or another professional legal society. The distinction between pro se representation and acknowledgement of one's capacity to advocate on behalf of another person, pursuing exercise of rights to due process, under the terms to which Charity Colleen Crouse has been subjective, is a material difference in regards to comportment and behavior that can be expected of all involved in the proceeding. The last 4 years' worth of efforts to seek redress via the judicial system has proven this. Charity Colleen Crouse argued in her original leave to file motion for a new trial that one of the major points of contention was the use of her legal filings as derivative actions in regards to other proceedings while she was personally denied any due process. Throughout this time, Charity Colleen Crouse has also been repeatedly denied any representation by an attorney, access to a prosecutor at any level of jurisdiction, or even a legitimate process by which to file reports with law enforcement or submit evidence. In in the United States District Court for the Northern District of Texas alone, Charity Colleen Crouse has tracked how her efforts were disabused to merely continue perpetuating derivative efforts connected to legal proceedings and financial arrangements aimed to benefit others in denial of her rights to due process. These others include those whom may be directly named as respondents or whom were availed of the benefits of the theft of Charity Colleen Crouse's prior legal work in connection with her reports concerning illegal activity. Specifically in this matter, Judge Irma Carrillo Ramirez was informed the same day as the date on the consent to proceed before a United States magistrate judge, January 17, 2020, in case number 3:CV-CV-0014-X-BH, that there were conflicts of interest with Judge Irma Carrillo Ramirez being designated as the magistrate judge in the proceeding, as reflected in an email response sent to the email address connected to the clerk of the court. Charity Colleen Crouse I don't care if you didn't see it. Did you not see it because you had already agreed to a kickback scheme with local law enforcement where they would just cut off or lose that email at that period in time so that it would appear that the deadline wasn't made? You have no excuse for saying you did not see it. Because even if you did not see that email, there's no way you did not see the record of me on site every time I filed. And, by the way, have access to the video feed as well as the testimonial evidence of the woman with blonde hair and light skin that was subjected to an act of electronic sexual violence based upon what was going on with the camera feed when I submitted my filing. So even if you didn't have that particular email, what about all of the other evidence that you've been intentionally ignoring and also manipulating? Charity Colleen Crouse explicitly identified how that specific electronic filing at that specific time fit the pattern of racketeering activity. By thus informing the court of this conflict of interest, Charity Colleen Crouse extended a professional consideration to Judge Irma Carrillo Ramirez that has not been reciprocated in the least during any current or prior effort of Charity Colleen Crouse to engage this or any other court. And that brings up the question, is it considered decorum to simulate oral sex when submitting a motion or a filing to the court on the clerk who receives the filing? Do you require prosecutors to engage in an act of electronic sex in order to consummate the filing? Because it seems, based upon what happened yesterday, instead of me being able to do things I needed to do, that's exactly what you wanted. And not only that, but the day before. The day before. Let's make sure. Yes, President's Day. That what's being set up right now is a paradigm whereby one cannot confirm their electronic submissions or transactions without agreeing to simulations that actually reflect on a visual spectrum as well as in terms of biophysiological confirmation as agreeing to an act of sex in order to process a digital transaction. I just want you to know, nowhere in that specific case, let me see if I can find it here, the name of the case. Give me a second. Dondi Properties Corp. Versus Commerce Savings and Loans Association. Nowhere in that case or the decision that's presented on the Northern District of Texas U.S. District Court website does it say that one, is expected to agree to perform sex acts, either literally or in some sort of digital representation, in order to be considered a professional. And even if they did, that calls into question the consideration of allowing for a representation of a sex act involving an attorney with a clerk, because then that calls into question potentially inappropriate relations between that clerk and the judge that might unduly influence the proceeding and aid and abet acts of fraud connected to the sureties on the case. Charity Colleen Crouse did not receive electronic notice regarding case number 3 colon 20 CV 00113 N BH, but did receive notice via postmail on January 21st, 2020, that the case had been assigned to the same magistrate judge. This process conflicts with the decision alleged to justify Judge Carrillo Ramirez's refusal to acknowledge Charity Colleen Krause's denial of consent to proceed before a United States magistrate judge via the order dated for February 11, 2020, that is now available on the electronic filing site. Charity Colleen Crouse received electronic notice per email that her application for admission pro hoc vis had been denied in both cases on February 9th, 2020. Let's see. February 9th, 2020 was exactly 1 year between February 9th, 2021. Now, even if you all determine there was some sort of benchmark that I needed to do as a derivative action, which, by the way, was the whole core of my case, that I was denied due process to instead be racketed for derivative actions that were actually attempting to launder money in connection with crime up to and including acts of terrorism. I was on site at the place I had been scheduled to be, going through a variety of completely inappropriate concurrent processes and acts of sabotage in regards to the literal event in which I was participating, while you allowed for, at least as represented in the media, an act of terrorism to occur in connection with another effort to interfere with not only my rights to due process, but the rights of another person. Both of those original electronic documents have been deleted. Remonstrations that automation of cases for pro se litigants precludes a need for consent need to be evaluated accordingly. When Charity Colleen Crouse attempted to file for application for admission pro hoc vis, Charity Colleen Crouse also submitted information on refusal to consent to assignment of her case to a magistrate judge. Judge Irma Carrillo Ramirez was again permitted to provide a filing of record in consideration of Charity Colleen Krause's case in violation of the appropriate local civil rules, as well as violation of the federal rules of civil procedure, compels consideration as to whether or not such an action was engaged with malicious intent. In fact, Charity Colleen Crouse was able to again identify how the notice from Judge Irma Carrillo Ramirez fit into the specific pattern of racketeering activity to which Charity Colleen Krause's previous legal filings had been subjected, and is exacerbated by their connection with the same elements to be considered in respect to Charity Colleen Krause's efforts to file a request for disciplinary action concerning Judge Renee Harris Toliver and Judge Ed Kinkeade. This calls into question whether Judge Irma Carrillo Ramirez was actually addressing the interest of the cases at hand as a judge or performing in a representative manner in regards to her colleagues, Judge Renee Harris Toliver and Judge Ed Kinkeade. If it was merely a matter of automation and Judge Irma Carrillo Ramirez neglected to consider the case on its merits, then this provides further proof of the need to reconsider the treatment of cases by pro se litigants and their assignment to a magistrate judge, especially in violation of the rights to consent accorded one under the law. No prior disclosure of Special Order 3-521 had been provided previously. Would a recognized attorney be required to submit oneself against his or her consent to a specific ascribement per an undisclosed special order, or would it violate Rule J of Dundee Properties Corp. Versus Commerce Savings and Loan Association, 121 FRD 284, Indy, Texas, 1988, in bank? Charity Colleen Crouse challenges the recurrent pattern of racketeering activity that is prevalent in the proceedings thus far in consideration of disclosure of potential conflicts of interest and their capacity to be otherwise accommodated. Such actions are ostensibly the sort of cooperation that professional legal representatives are held to so as to mitigate against allegations of engaging unprofessional or illegal conduct in performance of their duties. The fact that such cooperation is not accorded to a person forced to represent themselves pro se is a material factor in the proceeding. It is on this point that Charity Colleen Crouse appeals the denial of her application for admission pro hoc vis. The concerns raised herein and in consideration of the other allegations levied in the specific filings that Charity Colleen Crouse submitted and that were assigned to Judge Irma Carrillo Ramirez assure that the issue is not in fact moot, but at the core of the arguments presented for consideration in the original leave to file motion for a new trial. If Charity Colleen Crouse can be repeatedly denied legal counsel while attempting to exercise her rights to due process, and also to protect herself against efforts to extort her into agreement to cooperate with activities she is cognizant are illegal, then the court at some point has to weigh the profundity of the refusal of those deemed certified to be accorded the privileges and benefits of consideration as a formal member of the bar against the constitutional question of rights to due process being denied without just cause. In this case, exercise of rights to due process have been repeatedly denied by those who are accorded the privileges and benefits of membership in the bar, a membership which explicitly sanctions the sort of treatment of a member by another member, yet to which Charity Colleen Crouse has thus far been routinely subjected in efforts to represent herself pro se. If a judge can refuse to address and comport oneself with requisite decorum in consideration of a case presented by one representing oneself pro se, then consideration must be given as to the reason why. If it is a matter of official membership in a professional society, asserting a certain expectation of professional consideration of a peer or one affirmed to practice the law, as opposed to using legal filings for speculation on derivative matters, retaliation, or other areas beyond the primacy of the constitutional matter at hand, then the question is hereby called regarding the legitimacy of the bar itself. A good faith effort to engage the judicial branch of government in exercise of due process does not necessarily mean a subjugation of one's rights to the opportunistic gain of members of a bar association. This point was already raised as contestable per the decision provided in Judge Ed Kinkeade's order accepting findings, conclusions, and recommendation of the United States Magistrate Judge in support of Judge Renee Harris Toliver's decision in Charity Colleen Crouse versus Neuropsychiatric Center et al. Case number 3:19-CV-02280-K. I'm going to stop right here. Last night, in whatever that digital relay was to which I was exposed, that I understand has international implications. What I understand is that there was a disconcertment with the fact that I had identified the case regarding Miss Romero as being one of the primary offenses to which I had offered my contestation of the treatment I had received. Understand, in the course of my professional relationship with Miss Romero, if nothing else as an expert witness, I reviewed the information concerning the report provided by the caseworker in the assessment of custody after allegations of sexual abuse concerning the young girl. I also reviewed the deposition that was done with her by the opposing attorney. I also discussed with her a situation she had previously encountered when she was forced to go to a domestic violence shelter. All of those factors are 100% material to what would have been a legitimate protest of not only the case and the matters related to the case, but also considering my request for disciplinary action against Judge Farr in consideration of his behavior in the case, which also includes the misrepresentation of the process they engaged when it came to addressing the motion that was filed to contest the order that was the final judgment order in that case. All of those factors would have been considered evidence in what would have been a legitimate appeal of the case in which she was engaged, and would have also gone to establishing a demonstration of or a confirmation of my allegations of the means and manners in which the Health and Human Services system was being used to traffic women and children in connection with a criminal drug enterprise that also provided access to illicit patterns of distribution with national security implications, up to and potentially including efforts to compel one or extort one to agreeing to engage in acts of retaliation against law enforcement or even members of the military, interfere in matters connected to other countries that may also aid and abet acts of terrorism in those countries, and my concerns about other forms of smuggling, up to and including weapons. I will continue. To seek to use the pro se filing effort for the benefit of consideration connected to other cases or efforts while dispossessing the pro se litigant of his or her constitutional rights to due process would be considered a violation of the rules of decorum for attorneys asserted by the United States District Court for the Northern District of Texas in Dondi Properties Corp. Versus Commerce Savings and Loans Association. If no other means to exercise due process can be accorded to a plaintiff than to have access to representation that is permitted to perform in accordance with a select professional society, then it is requested that for consideration of the specific cases presented, Charity Colleen Crouse be granted the status of a bar member pro hoc vis, attendant with the assistance that would be available to a representative of the law seeking to mount a case for prosecution. Now, this was signed at 10:13 p.m. Central Standard Time on February 12th, 2020. I stand behind everything that is said in here. I would not change a word of the original motion except to add more evidence in consideration, and also to request a specific expediency in consideration of the egregious harm that has been done in this abuse of the judicial system for a very protracted period of time. I also want to make a distinction. My effort to apply for the job at Whole Foods was 100% in good faith for a variety of reasons. I personally do not consider it to be an insult to me, personally, to get a job where I make a wage and maybe meet good, competent, qualified people, doing something within a structure that actually could be very commendable and complementary with what I want to do anyway, especially if it assists in providing people with access to good, wholesome, safe food, and also would be a part of a culture that might be able to provide, some sort of alternative. I also understand and have personal experience now with the fact that they have a very good benefits program. And these are the kinds of things that people who want to be gainfully employed and take care of their own family without being forced into a situation where they're dependent on public assistance and sublimating or subordinating their own life or desires to the accrual of political capital for people who provide public assistance. Not only that, the training I went through, had it not been so completely racist, could have provided a possibility for other kinds of expression. Was it derivative? Well, actually, it was not. Food access is very important. The logistics concerning food access, including emergency food access, is very important. Ideally, going through a process of certification and verification, including when it comes to transportation, shipping, and receiving for something like organic food, were the standards associated with organic food to be uniformly applied and to be matched with a consideration of that which could compromise the integrity of the product as well as the safety of all involved in the production, transport, and consumption of those food products is very important. It's also important to note that certain food products use certain chemicals that, as I read out loud yesterday, and I'm sure somebody with surveillance capabilities was able to ascertain, is actually materially relevant in consideration of controlling potential misabuse of certain component ingredients for the development of chemical warfare. That was part of the reason why I was not able to stay on site. It wasn't a joke. It wasn't a simulation. Apparently, it wasn't a derivative action either. Please put that into consideration. It was 100% just as good faith as what it was when I tried to go through the judicial system in order to seek justice for myself and other women who very well right now could be operating small businesses with each other to provide for our community. They may not want to be involved as an industrial inspector of industrial facilities. They may not be interested in trying to get the experience or the credentialing they need to be able to provide inspections of public works that might be a part of municipal financing. I am. They would be interested in other things, and they would be in leadership with me in my community if it weren't for this repeated process of trying to extort and coerce us into agreeing to cooperate with domestic terrorism that has international implications.